if somebody refuses to sign a power of attorney, or it's just an oversight, interestingly enough, we do see a lot of seniors who have last wills and testaments, but they do not have powers of attorney. I can't imagine allowing somebody to leave your office without executing all of their documents. But I've had a handful of individuals who flat out just refused to sign durable powers of attorney. They're usually the patriarch of the family who says, I'm not allowing anyone to do anything for me. My father died in his sleep. I'm going to die in my sleep. I'm going to be fine until the day I die. And those are usually the people who need it most. Yeah. So what happens if they haven't executed that durable power of attorney? As long as there's no need, very often things are fine, but sometimes there's a need. For instance, I mentioned before, there may be a need to apply for Medicaid, or there may be a need to admit to a nursing home or an assisted living facility, or to move money, or something has to happen. So at that point, usually a family member is seeking a guardianship over their loved one. And the guardianship is a very involved process. It's very procedural so long as nobody challenges it. But it is very often, even though it is procedural and even though there may not be a challenge to it, the normal time frame is 8 to 12 weeks. And by the time you're done paying the attorney for the proposed guardian, the attorney for the fee for the court-appointed attorney, which everybody's entitled to representation, and then the fees for 2 doctors who must evaluate the individual, you're usually into this for $10,000 to $15,000. And as I said before, it's just totally unnecessary. A simple durable power of attorney would have sufficed.